Hey man, it's B1 Brother Moses, man, and we got work to do. So as we begin to get into this content here, we already know what it is. I've already told you what I'm going to be discussing. So now it's just time to get into the work. Make sure we get this documented while it's still fresh.
How to convince Black women, how
to believe that Black women are disposable.
How that you need to desperately pursue marriage with him. How
they are all around our lives, landlords, bosses, judges, doctors, teachers, and Jesus.
I'm trying to think about how they were able to accomplish that. The only thing that I can come up with is blind Black male worship.
I keep saying it over and over again that spiritual debt is real.
How global trade.
Annie Farmer came out against the convicted P-Files co-conspirator, British elitist Ghislaine Maxwell. Maxwell pled not guilty to sex trafficking and 5 other charges. Maxwell was held without bail July 12, 2021. In the file, it has this quote: "She assisted, facilitated, and contributed to Jeffrey Epstein's abuse of minor girls by, among other things, helping Epstein to recruit, groom, and ultimately abuse victims." Section 1. What will Ghislaine Maxwell be convicted of? Section 1A will include the Maxwell Docket. 1B will include USA versus Maxwell. And 1C, Guthrie versus Maxwell. U.S. District Court, District of New Hampshire, Concord, criminal docket for case number 120-MJ-00132-AJ, all defendants. Case title, USA v. Maxwell. Date filed, July the 2nd, 2020. Assigned to Magistrate Judge Andrea K. Johnstone. Defendant, Ghislaine Maxwell. Pending counts: 18 U.S.C. 371, conspiracy to entice minors to travel to engage in illegal sex acts. 18 U.S.C. 2422 and 2, enticement of a minor to travel to engage in illegal sex acts. 18 U.S.C. 371, conspiracy to transport minors with intent to engage in criminal sexual activity. 18 U.S.C. 2423A and 2, transportation of a minor with intent to engage in criminal sexual activity. Perjury. Highest offense level, felony. Plaintiff, USA. Represented by John S. Davis, U.S. Attorney's Office, James C. Cleveland Federal Building, 53 Pleasant Street, 4th floor, Concord, New Hampshire. Lead attorney on file. Docket text: arrest, removal of Ghislaine Maxwell, copy of warrant and indictment from Southern District of New York, White Plains, New York, case number 20-CR330. Notice of hearing as to Ghislaine Maxwell. Removal hearing via video conference set at 7/20/2020, 3:30 p.m. before Magistrate Judge Andrea K. Johnstone. Public access findings as to Ghislaine Maxwell, so ordered by Magistrate Judge Andrea Johnstone. Minute entry for proceedings held before Magistrate Judge Andrea Johnstone. Removal hearing as to Ghislaine Maxwell held on 7/2/2020. The court found the defendant knowingly and voluntarily waived an in-court hearing. Defendant advised of rights and charges, waived identity hearing. Detention hearing to be held in prosecuting district. Attorney, Allison Moe, John Davis. Defendant's attorney, Lawrence Vogelman. Total hearing time, 17 minutes. It was committed to another district, District of Southern District of New York, so ordered by Magistrate Judge Andrea K. Johnstone. Section 1B, USA v. Maxwell. Arrest warrant. You are commanded to arrest and bring before a United States magistrate judge without unnecessary delay. Person, Ghislaine Maxwell, who is accused of an offensive violation based on the following document filed with the court: indictment. This offense is briefly described below as conspiracy to entice minors, enticement of a minor, conspiracy to transport minors, transportation of a minor, and perjury. Honorable Lisa Margaret Smith, U.S. Magistrate Judge. United States District Court, Southern District of New York, United States of America versus Ghislaine Maxwell. Defendant, sealed indictment, 20 CR 330. Count 1, conspiracy to entice minors to travel to engage in illegal sex acts. The grand jury charges. Overview. 1. The charges set forth herein stemmed from the role of Ghislaine Maxwell, the defendant, in the sexual exploitation and abuse of multiple minor girls by Jeffrey Epstein. In particular, from at least in or about 1994, up to and including at least in or about 1997, Maxwell assisted, facilitated, and contributed to Jeffrey Epstein's abuse of minor girls by, among other things, helping Epstein to recruit, groom, and ultimately abuse victims known to Maxwell and Epstein to be under the age of 18. The victims were as young as 14 years old when they were groomed and abused by Maxwell and Epstein, both of whom knew that certain victims were in fact under the age of 18. 2. As a part and in furtherance of their scheme to abuse minor victims, Ghislaine Maxwell, the defendant, and Jeffrey Epstein enticed and caused minor victims to travel to Epstein's residences in different states, which Maxwell knew and intended would result in their grooming for and subjection to sexual abuse. Moreover, in an effort to conceal her crimes, Maxwell repeatedly lied when questioned about her conduct, including in retaliation to some of the minor victims described herein, when providing the testimony under oath in 2016. Factual background. During the time periods charged in this indictment, Ghislaine Maxwell, the defendant, had a personal and professional relationship with Jeffrey Epstein and was among his closest associates. In particular, between in or around 1994 or 1997, Maxwell was in an intimate relationship with Epstein and was paid by Epstein to manage his various properties. Over the course of their relationship, Maxwell and Epstein were photographed together over multiple occasions, including in the below image. Beginning in at least 1994, Ghislaine Maxwell, the defendant, enticed and groomed multiple minor girls to engage in sex acts with Jeffrey Epstein through a variety of means and methods, including but not limited to the following. A. Maxwell first attempted to befriend some of Epstein's minor victims prior to their abuse, including by asking the victims about their lives, their schools, and their families. Maxwell and Epstein would spend time building friendships with minor victims by, for example, taking minor victims to the movies or shopping. Some of these outings would involve Maxwell and Epstein spending time together with a minor victim, while some would involve Maxwell or Epstein spending time alone with the minor victim. Having developed a rapport with the victim, Maxwell would try to normalize sexual abuse for a minor victim by, among other things, discussing sexual topics, undressing in front of the victim, being present when a minor victim was undressed, and or being present for sex acts involving the minor victim and Epstein. Maxwell's presence during minor victims' interactions with Epstein, including interactions where the minor victim was undressed or that involved sex acts with Epstein, helped put the victims at ease because an adult woman was present. For example, in some instances, Maxwell would massage Epstein in front of the minor victim. In other instances, Maxwell encouraged minor victims to provide massages to Epstein, including sexualized massages during which a minor victim would be fully or partially nude. Many of those massages resulted in Epstein sexually abusing the minor victims. In addition, Epstein offered to help some minor victims by paying for travel and educational opportunities, and Maxwell encouraged certain victims to accept Epstein's assistance. As a result, victims were made to feel indebted and believe that Maxwell and Epstein were trying to help them. Through this process, Maxwell and Epstein enticed victims to engage in sexual activity with Epstein in some instances. Maxwell was present for and participated in the sexual abuse of minor victims. Some such incidents occurred in the context of massages, which developed into sexual encounters. Ghislaine Maxwell, the defendant, facilitated Jeffrey Epstein's access to minor victims, knowing that he had a sexual preference for underage girls and that he intended to engage in sexual activity with those victims. Epstein's resulting abuse of minor victims included, among other things, touching a victim's breast, touching a victim's genitals, touching a sex toy such as a vibrator on a victim's genitals, directing a victim to touch Epstein while he masturbated, and directing a victim to touch Epstein's genitals. Maxwell and Epstein's victims. Between approximately in or about 1994 and in or about 1997, Ghislaine Maxwell, the defendant, facilitated Jeffrey Epstein's access to minor victims by, among other things, inducing and enticing and aiding and abetting the inducement and enticing of multiple minor victims. Victims were groomed and or abused at multiple locations, including the following: a multi-story private residence on the Upper East Side of Manhattan, New York, owned by Epstein, the New York residence, which is depicted in the following photograph. An estate in Palm Beach, Florida, owned by Epstein, the Palm Beach residence, which is depicted in the following photograph. A ranch in Santa Fe, New Mexico, owned by Epstein, the New Mexico residence, which is depicted in the following photograph. Maxwell's personal residence in London, England. Among the victims induced or enticed by Ghislaine Maxwell, the defendant, were minor victims identified herein as minor victim 1, minor victim 2, and minor victim 3. In particular, during time periods relevant to this indictment, Maxwell engaged in the following acts, among others, with respect to minor victims. Maxwell met minor victim 1 when minor victim 1 was approximately 14 years old. Maxwell subsequently interacted with minor victim 1 on multiple occasions at Epstein's residences, knowing that minor victim 1 was under the age of 18 at the time. During these interactions, which took place between approximately 1994 and 1997, Maxwell groomed minor victim 1 to engage in sexual acts with Epstein through multiple means. First, Maxwell and Epstein attempted to befriend minor victim 1, taking her to the movies and on shopping trips. Maxwell also asked minor victim 1 about school, her classes, her family, and other aspects of her life. Maxwell then sought to normalize inappropriate and abusive conduct by, among other things, undressing in front of the minor victim 1 and being present with minor victim 1 undressed in front of Epstein. Within the first year after Maxwell and Epstein met minor victim 1, Epstein began sexually abusing minor victim 1. Maxwell was present for and involved in some of this abuse. In particular, Maxwell involved minor victim 1 in group sexualized massages of Epstein. During those group sexualized massages, Maxwell and or minor victim 1 would engage in sex acts with Epstein. Epstein and Maxwell both encouraged minor victim 1 to travel to Epstein's residences in both New York and Florida. As a result, minor victim 1 was sexually abused by Epstein in both New York and Florida. Minor victim 1 was enticed to travel across state lines for the purpose of sexual encounters with Epstein, and Maxwell was aware that Epstein engaged in sexual activity with minor victim 1 after minor victim 1 traveled to Epstein's properties. including in the context of a sexualized massage. Maxwell interacted with minor victim 2 on at least one occasion, in or at 1996 at Epstein's residence in New Mexico when minor victim 2 was under the age of 18. It's hard. Minor victim 2 had flown into New Mexico from out of the state at Epstein's invitation for the purpose of being groomed for and were subjected to acts of sexual abuse. Maxwell knew that minor victim 2 was under the age of 18 at the time. While in New Mexico, Maxwell and Epstein took minor victim 2 to a movie, and Maxwell took minor victim 2 shopping. Maxwell also discussed minor victim 2's school, classes, and family with minor victim 2. In New Mexico, Maxwell began her efforts to groom minor victim 2 for abuse by Epstein, by, among other things, providing an unsolicited massage to minor victim 2, during which minor victim 2 was topless. Maxwell also encouraged minor victim 2 to massage Epstein. Maxwell groomed and befriended minor victim 3 in London, England, between approximately 1994 and 1995, including during a period of time in which Maxwell knew that minor victim 3 was under the age of 18. Among other things, Maxwell discussed minor victim 3's life and family with minor victim 3. Maxwell introduced minor victim 3 to Epstein and arranged for multiple interactions between minor victim 3 and Epstein. During those interactions, Maxwell encouraged minor victim 3 to massage Epstein, knowing that Epstein would engage in sex acts with minor victim 3 during those massages. Minor victim 3 provided Epstein with the requested massages, and during those massages, Epstein sexually abused minor victim 3. Maxwell was aware that Epstein engaged in sexual activity with minor victim 3 on multiple occasions, including at times when minor victim 3 was under the age of 18, including in the context of a sexualized massage. Maxwell's efforts to conceal her conduct. In or around 2016, in the context of a deposition as part of the civil litigation, Ghislaine Maxwell, the defendant, repeatedly provided false and perjurious statements under oath regarding, among other objects, her role in facilitating the abuse of minor victims by Jeffrey Epstein, including some of the specific events and acts of abuse detailed above. From at least in or about 1994 up to and including in or about 1997 in the Southern District of New York and elsewhere, Ghislaine Maxwell, the defendant, Jeffrey Epstein, and others known and unknown, willingly and knowingly did combine, conspire, confederate, and agree together and with each other to commit an offense against the United States, to wit, enticement in violation of Title 18, United States Code Section 2422. It was a part and object of the conspiracy that Ghislaine Maxwell, the defendant Jeffrey Epstein, and others known and unknown would and did knowingly persuade, induce, entice, and coerce one and more individuals to travel in interstate and foreign commerce, to engage in sexual activity for which a person can be charged with a criminal offense in violation of Title 18, United States Code, Section 2422. Overt acts. In furtherance of the conspiracy and to effect the illegal object thereof, the following overt acts, among others, were committed in the Southern District of New York and elsewhere. Between in or around 1994 and in or about 1997, when minor victim 1 was under the age of 18, Maxwell participated in multiple group sexual encounters with Epstein and minor victim 1 in New York and Florida. In or about 1996, when minor victim 1 was under the age of 18, minor victim 1 was enticed to travel from Florida to New York for purposes of sexually abusing her at the New York residence in violation of New York Penal Code Section 13055. In or about 1996, when minor victim 2 was under the age of 18, Maxwell provided minor victim 2 with an unsolicited massage in New Mexico, during which minor victim 2 was topless. Between in or about 1994 and in or about 1995, when minor victim 3 was under the age of 18, Maxwell encouraged minor victim 3 to provide massages to Epstein in London, England, knowing that Epstein intended to sexually abuse minor victim 3 during those massages. Title 18, United States Code, Section 371. Whew. Count 2. My. That was just count 1. That was count 1. That was just count 1. This is emotionally taxing and hard. But if we're ever going to affect any change towards protecting ours in whatever communities and jurisdictions we live, this is the language of protection. This is the language of retaliation. This is the language of protection, as so used in the laws and statutes of America. Street codes may be different, but this is as it is. Count 2. Let's breathe. Let's breathe. Count 2. Enticement of a minor to travel to engage in illegal sex acts. The grand jury further charges. The allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within. From at least in or about 1994 up to and including in or about 1997 in the Southern District of New York and elsewhere, Ghislaine Maxwell, the defendant, knowingly did persuade, induce, entice, and coerce an individual to travel in interstate and foreign commerce to engage in sexual activity for which a person can be charged with a criminal offense, and attempted to do the same and aided and abetted the same, to wit, Maxwell persuaded, induced, enticed, and coerced minor victim 1 to travel from Florida to New York on multiple occasions with the intention that minor victim 1 would engage in one or more sex acts with Jeffrey Epstein in violation of New York Penal Code Section 130.55. Title 18, United States Code, Sections 2422 and 2. Count 3, conspiracy to transport minors with intent to engage in criminal sexual activity. The grand jury further charges. The allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within. From at least in or about 1994 up to and including in or about 1997. The Southern District of New York and elsewhere, Ghislaine Maxwell, the defendant Jeffrey Epstein, and others known and unknown willfully and knowingly did combine, conspire, confederate, and agree together and with each other to commit an offense against the United States, to wit, transportation of minors in violation of Title 18, United States Code, Section 2423A. It is part and object of the conspiracy that Ghislaine Maxwell, the defendant, Jeffrey Epstein, and others known and unknown would and did knowingly transport an individual who had not attained the age of 18 in interstate and foreign commerce, with intent that the individual engage in sexual activity for which a person can be charged with a criminal offense in violation of Title 18, United States Code, Section 2423A. Overt acts in furtherance of the conspiracy and to effect the illegal object thereof. The following overt acts, among others, were committed in the Southern District of New York and elsewhere between in or about 1994 and in or about 1997, when minor victim 1 was under the age of 18. Maxwell participated in multiple group sexual encounters with Epstein and minor victim 1 in New York and Florida. In or about 1996, when minor victim 1 was under the age of 18. Minor victim 1 was enticed to travel from Florida to New York for purposes of sexually abusing her at the New York residence in violation of New York Penal Law Section 130.55. In or about 1996, when minor victim 2 was under the age of 18, Maxwell provided minor victim 2 with an unsolicited massage in New Mexico, during which minor victim 2 was topless. Between in or about 1994 and in or about 1995, when minor victim 3 was under the age of 18, Maxwell encouraged minor victim 3 to provide massages to Epstein in London, England, knowing that Epstein intended to sexually abuse minor victim 3 during those massages. Title 18, United States Code, Section 371. Count 4. Breathe. We're going to breathe through it, but we're definitely going to breathe. This is draining. This is emotionally taxing, but this is the work that must be done if we are ever going to effect the change of protecting ours in whatever Black community or jurisdiction we reside. This is that work that must be done. These are the laws and statutes of the America which we live, and in order for us to protect our babies, we must be well versed in the laws and the statutes. If there's one mark that we may leave, that we must leave as the Black men in our generation, it must be the protection of Black babies. The overall vision: secure Black households. Count 4. Transportation of a minor with intent to engage in criminal sexual activity. The grand jury further charges: the allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within. From at least in or about 1994 up to and including in or about 1997 in the Southern District of New York and elsewhere, Ghislaine Maxwell, the defendant, knowingly did transport an individual who had not attained the age of 18 in interstate and foreign commerce, with the intent that the individual engage in sexual activity for which a person can be charged with a criminal offense, and attempted to do so, and aided and abetted the same, to wit, Maxwell arranged for minor victim 1 to be transported from Florida to New York, on multiple occasions with the intention that minor victim 1, who was under the age of 14, minor victim 1 was under the age of 14. That minor victim 1 would engage in one or more sex acts with Jeffrey Epstein in violation of New York Penal Law, Section 13055. Title 18, United States Code, Sections 2423A and 2. Count 5, perjury. The grand jury further charges the allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within. On or about April 22nd, 2016, in the Southern District of New York, Ghislaine Maxwell, the defendant, having taken an oath to testify truthfully in a deposition in connection with a case then pending before the United States District Court for the Southern District of New York under docket number 15, CIV 7344, 15 Civil 7344, knowingly made false material declarations, to wit, Maxwell gave the following underlined false testimony. Question: did Jeffrey Epstein have a scheme to recruit underage girls for sexual massages, if you know? Maxwell answers, I don't know what you're talking about. Question: list all the people under the age of 18 that you interacted with at any of Jeffrey's properties. Maxwell answered, I'm not aware of anybody that I am not aware of anybody that I interacted with other than obviously the plaintiff, who was 17 at this point. Title 18, United States Code, Section 1623. Count 6, perjury. The grand jury further charges the allegations contained in paragraphs 1 through 8 of this indictment are repeated and realleged as if fully set forth within. On or about July 22nd, 2016, in the Southern District of New York, Ghislaine Maxwell, the defendant, having taken an oath to testify truthfully on or about July 22nd, 2016, in the Southern District of New York, Ghislaine Maxwell, the defendant, having taken an oath to testify truthfully in a deposition in connection with a case then pending before the United States District Court for the Southern District of New York under docket number 15, CIV 7344. Docket number 15, civilian 7344, knowingly made false material declarations, to wit, Maxwell gave the following underlined false testimony. Question: were you aware of the presence of sex toys or devices used in sexual activities in Mr. Epstein's Palm Beach house? Maxwell answers, no, not that I recall. Question: do you know whether Mr. Epstein possessed sex toys or devices used in sexual activities? Maxwell's answer, no. Question: other than yourself and the blonde and brunette that you have identified as having been involved in three-way sexual activities, with whom did Mr. Epstein have sexual activities? Maxwell answers, I wasn't aware that he was having sexual activities with anyone when I was with him when I was with him other than myself. Question: I want to be sure that I'm clear. Is it your testimony that in the 1990s and 2000s, you were not aware that Mr. Epstein was having sexual activities with anyone other than yourself and the blonde and brunette on those few occasions when they were involved with you? Maxwell answers, that is my testimony. It is correct. Question: is it your testimony that you've never given anybody a massage? Maxwell answers, I have not given anyone a massage. Question: you never gave Mr. Epstein a massage. Is that your testimony? Maxwell answers, that is my testimony. Question: you never gave minor victim 2 a massage. Is your testimony? Maxwell answers, I never gave minor victim 2 a massage. Title 18, United States Code, Section 1623, Acting United States Attorney, Audrey Strauss. United States District Court, Southern District of New York, United States of America, v. Ghislaine Maxwell, defendant, indictment, 18 U.S.C. Section 371, 1623, 2422, 243, 2423, A and 2. All right, we're getting into another section. I got to take an emotional regulation break. I try to do emotional regulation as often as I can with breathing, and I encourage anyone who's able to bear through this international sex traffickers indictment. Anyone who's ever able to survive Maxwell, to breathe. We don't want that negative energy congesting our bowels. We don't want to be all backed up, because it can only be motivation for us to continue on our vision. Call it safe or call it secure. Black households. Secure Black households. The mission is to prevent sexual exploitation of our babies. And these are the laws and the statutes of the United States under which the rape culture prevails. And as long as our men are not informed on the actual laws and statutes, we stand no chance to protect our babies. This is the work and the duty of men. Public access findings. Appears to be just a tad too big. Salute. Salute. It appears to be just a tad too big to share completely on the screen. I will be speed reading through it. We see that it is accessible on the screen, but because it's not legible on the screen, I will remove it from the screen and speed read through it myself, if that is all right. Gotta put on my blue blockers here. United States District Court for the District of New Hampshire, United States of America v. Ghislaine Maxwell, case number 20-MJ-132-AJ-1, public access findings. Background. This hearing has taken place during a public health emergency caused by the COVID-19 outbreak. All parties to this proceeding, including the court and appearing remotely via video, in light of the anticipated volume of public and media interest in the operational capacity limitations of video conference technology, public and media access to the proceeding will be via telephonic conference. The court's protocols for this hearing are laid out in Standing Order 20-7, March 23, 2020. The court finds that conducting this hearing via video under the unique circumstances presented by the COVID-19 pandemic is the best way to ensure the safety of all litigants, court personnel, and the public at large. All findings made in the court's prior standing orders are incorporated herein. See Standing Orders 20-5 from March 20th, 2020 and 20-21 from June 17th, 2020. The hearing held today will be an initial appearance and removal hearing for defendant Ghislaine Maxwell. Today's hearing has been noticed as a video hearing. In the event defendant consents to proceed, the court makes the findings below. Before convening this video telephone hearing, the court carefully considered the defendant's Sixth Amendment right to public court proceedings and the public's and press's First Amendment rights to in-person access to such proceedings. See Buki v. United States, 662 F3D 1822, First Circuit 2011. Citing Waller v. Georgia, 467 U.S. 3948, 1984. Press Enter Company versus Superior Court of California, Riverside County. These are the precedents. 464 U.S. 501, 509 to 10, 1984. This order details my findings. Partial rather than total closure. Excuse me. This section deals more with the procedural of why they are using teleconference, which it goes across jurisdictions. And so they have to use a lot of court precedences and in order to validate its legitimacy, since the Internet and Telecommunications Act, publishing, radio, they also use a number of different rationale as to legitimize why the telephone conference system is constitutional. I will not sit here and read this entire thing. They talk about for public safety concerns and validate that. See United States v. Al-Hamedi. In conclusion, let's go to the conclusion. In sum, the court finds that in this case, a partial closure of court proceedings is necessary and that today's hearing will be conducted by video and telephone conference. This partial closure is justified by the substantial interest of protecting public health and safety from the spread of COVID-19 and is narrowly tailored to protect that interest. The public maintains the opportunity to access these proceedings in full by telephone. Andrea K. Johnston, United States Magistrate Judge. Then it has the final document after that. All right. Whew. Hey, this is hard work. I could not endure this without emotional regulation. So if you are able to if you're able to participate during this public hearing or the public reading of the indictment against Ghislaine Maxwell, the global or international sex trafficker, remember to breathe as I breathe. Exhale some of that positive energy, as well as get out some of that negative energy. It creates a sense of anxiety. I know scientists like to call it stress or cortisol, but got to get that out so that we may be able to inhale some of the positive news that comes. Like as we continue to learn, for example, the statutes and laws, how they are written, the codes that they're using. If our mission is to fight against sex trafficking, and these are the legitimate cases that they use, then yes, we should continue to quote these cases, to read these cases, understand the flaws and the advantages of using these cases as we bring forth our information to those in our network. Those in our network who are acquainted with criminal and civil lawyers. The reason that we take this stance today is to establish not only a legacy of fighting back in our era, but also to take the fight to those who always seem to get away. They always seem to escape criminal justice. And if we can't do that, then we will only be supporting victim and survivor relief programs. The best that we could do is pass out index cards with the emergency hotline number on them, local resources that they may be able to, that they will have access to if they need. We'll be able to have the conversation, but it will be the conversation without context. What can we actually do? What is our solution besides learning that we may teach others, and then learning that the people we teach they will be in the position to extend the conversation into the spaces we can't reach. I can call a congressperson. They can say, thank you for your presentation. As a constituent of mine, I value all of the work and research that you put into this. I'm going to pass it to one of my interns for review. They have a couple of channels that they're going to reach out to, and we'll see if we can get some momentum on this. I love the idea. Let's set up a time where we can have some coffee and discuss this further. Again, thank you, and I appreciate your concern here. We're all concerned. We can keep getting that runaround playing the political game. But when I tell you that the predators are protected, it is because, number one, the laws are written that way. Number two, when it comes to fighting, we're not using even the loopholes that are in these laws to say, well, that law doesn't apply. We're missing the point about what legal text even is. Why do they keep saying it over and over again? Why do they keep referring to these same sex trafficking laws, no matter which cases that you use? Our issue is with jurisdiction. If it's an event that takes place and we have B1 folks or Black first mentality, people who understand the plight of Black folks, who understand that the message has been hijacked, who understand that the message is being whitewashed, who understand that the message is being drowned out, that you can try to find this type of information in whatever you click on YouTube, and YouTube already has built into you have a profile. Google has your profile. Google has you profiled. For every marketer, for every website you go to, you have a digital profile that exists for you. And no matter where you go as a Black person, if your perspective has not been primarily driven towards Black spaces, Black concepts, Black excellence, I want to find Black businesses, I want to find places where I can volunteer. The websites that you go to are Black hosted content creators. If you're not that person, then your profile is diverse. You have a diverse profile. You have a diverse profile, digital profile. I don't have a problem with diverse profiles. But the part of your profile that is Black, when you do start typing into that Google search box, what you type in will be spit out by Google based off of not only the information present, there's hundreds of thousands or millions of things that are queried. You can see page after page, if you ever look down, how many different findings they will have whenever you put anything into that search bar. But the ones that hit the top are the ones that they've considered and created based on your profile. And if your profile is so diverse that it doesn't find positive information anymore, then it's up to us to that further cements why we must push forward. I don't believe in a gender war. I believe that there is no viable separation of the masculine and feminine energy. Any attempt is failure. Any attempt to allow such bonds to dissolve are the man's failure. The nature, the genuine nature of every woman that I've met has been cohesion, harmony, without the molestation of bastard men and bastard politics. The women that I've ever met have been glued to their family, to their friends, to their communities. Drama aside, drama is a big genre. We can laugh at drama. We can smile at drama. We could cry at drama. We can celebrate the victories of drama. We can root against the bad guys in the genre called drama. Our family drama can cut like a knife to where we don't speak often to the deathbed. Some incidents will not be forgiven until the casket closes. Most of them, though, most of the slights that we feel aggrieved from our family are forgivable. If you're in my family, many of those come with jokes. We try to maintain a humorous, light, pleasant decorum. It doesn't come hard. We love each other. And that genuine love is what we miss in this digital era. Because every time we click, there are thousands upon thousands of negative things that we can see. Black men being another negative image is what we stand against as genuine, authentic Black men. We're not unicorns. We fail. I'm not a unicorn. I break hearts daily. The two to which I am devoted to making amends towards daily. My wife and my daughter, I break their hearts daily. Every morning they wake up to a world where another man can not only take them out, but can take their superhero out, can cause their life the devastation that they would only read about in their history books or watch on one of these television shows. And there's no way around it. I am responsible for creating a space that is protective of my family. What I do infringes upon their right to security. When I was going to the strip club, even before COVID was not what stopped me. My wife gave me a bit of insight. My daughter gave me a bit of insight. I love you anyway was the insight. Mind blown. I was failing my family every time I made the excuse that I was doing it for the good, that I actually love people. And these are, what they call the least of these. These are, if you want to find a space where Black women could actually use a Black man's help, go to the strip club. If you call any of the women in your Facebook list, my family and such, and none of them need actual help, then there's always somewhere where I can go where someone would need help. But I was part of the problem. This is a case about sex trafficking. This is an international sex trafficker, Ghislaine Maxwell. And while we've just read the indictment against her, the next part of that is not just looking at the predator, the criminal, the offender, but also hearing the words or allowing the voice for the survivor to come through. Section 1(3), Gouffre versus Maxwell. Breathe. There's some things that I'm going to have to read that's going to make it hard to breathe. United States District Court, Southern District of New York, Virginia L. Guthrie versus Ghislaine Maxwell, defendant. Plaintiff Virginia L. Guthrie, formerly known as Virginia Roberts Guthrie, for her complaint against defendant Ghislaine Maxwell, avers upon personal knowledge as to her own acts and status, and otherwise upon information and belief. Nature of the action. This suit arises out of the defendant Maxwell's defamatory statements against plaintiff Jeffrey. As described below, Jeffrey was, excuse me, and I'm gonna have to restart this because I don't know how to pronounce the last name, but the case was against Jeffrey Epstein, and for me to actually remember the names, I'm going to take the liberty to pronounce Giuffre as Jeffrey also. And I know that is dehumanizing for the actual survivor. But I need that liberty. At some point, maybe I will attempt to learn how to pronounce white females' names and the surnames of white men and such. But I just don't know how, and I'll keep going back and forth. It could be Guy-Free, it could be Giuffre. I'm just not sure. So I'll continue until corrected. Plaintiff Jeffrey. As described below, I can't do that. Giuffre. We'll go with Giuffre, final answer. This suit arises out of defendant Maxwell's defamatory statements against plaintiff Giuffre. As described below, Giuffre was a victim of sexual trafficking and abuse while she was a minor child. A minor child. Defendant Maxwell not only facilitated that sexual abuse, but most recently, wrongfully subjected Giuffre to public ridicule, contempt, and disgrace by, among other things, calling Giuffre a liar in published statements with the malicious intent of discrediting and further damaging Giuffre worldwide. Jurisdiction and venue. This is an action for damages and an amount in excess of the minimum jurisdictional limits of this court. The court has jurisdiction over this dispute pursuant to 28 U.S.C. Section 1332 diversity jurisdiction, as Giuffre and Maxwell are citizens of different states and the amount in controversy exceeds $75,000 exclusive of interest and costs. The court has personal jurisdiction over Maxwell. Maxwell resides in New York City, and this action arose and defamatory statements were made within the Southern District of New York. Venue is proper in this court as the cause of action arose within the jurisdiction of this court. Parties. Plaintiff Giuffre is an individual who is a citizen of the state of Colorado. Defendant Maxwell is a domiciled in the Southern District of New York, is not a citizen of the state of Colorado. Factual allegations. Virginia Giuffre became a victim of sex trafficking and repeated sexual abuse after being recruited by Ghislaine Maxwell and Jeffrey Epstein when Giuffre was under the age of 18. Between 1999 and 2002, with the assistance and participation of Maxwell, Epstein sexually abused Giuffre at numerous locations, including his mansions in West Palm Beach, Florida, and in this district. Between 2001 and 2007, with the assistance of numerous co-conspirators, Epstein abused more than 30 minor, underaged girls. A fact confirmed by state and federal law enforcement. As part of their sex trafficking efforts, Epstein and Maxwell intimidated Giuffre into remaining silent about what had happened to her. In September 2007, Epstein entered into a non-prosecution agreement, NPA, that barred his prosecution for numerous federal sex crimes in the Southern District of Florida. In the NPA, the United States additionally agreed that it would not institute any federal criminal charges against any potential co-conspirator of Epstein. In the NPA, the United States additionally agreed that it would not institute any federal charges against any potential co-conspirator of Epstein. Gotta do it. Excuse me for the aside. Jeffrey Epstein's Little Black Book, redacted. Documentcloud.org documents. Jeffrey Epstein's Little Black Book, redacted. 2004 to 2005. 2001 to 2007. So we have Epstein's list between 2004 and 2005, and we have the list of either patrons or co-conspirators. And we will just take a quick look at how long this list is, since there was somebody who was so good at defending sex trafficking and sex traffickers and those who patronized the sex trafficking ring, that none of these folks would be allowed to be prosecuted under the first, what did they call it? I don't want to mince words. I want to make sure we are using their exact words. I'm B1 Brother Moses. I do not play that. No, none of that. I do not believe in plagiarism. This will be exactly what it is and nothing more than that. Numerous co-conspirators in the abuse of more than 30 minor underage girls, a fact that was confirmed by state and federal law. These are factual allegations, not emotions, not opinions. In September 2007, Epstein entered into a non-prosecution agreement that barred his prosecution for even before the co-conspirators received their immunity. It barred his prosecution for numerous federal sex crimes in the Southern District of Florida. So Florida took it off the books already, immediately. Florida. I can go into why the Southern District of Florida has direct correlation with what we're seeing today, or I can keep going. I choose the latter. He was protected. The United States additionally agreed that it would not institute any federal charges against any potential co-conspirators of Epstein. So again, to be thorough, Jeffrey Epstein's redacted book. I could scroll out and you'll see that there is a lot that's been redacted, or I can scroll in, and since our Justice Department was not able to find it right for these, I won't read all of these names, but I will scroll them through. If you see somebody that you know personally, breathe. And if they're just the celebrities or whatnot, understand why we are against celebrity worship. Madrid, Spain. London. London, England. The New York residence, the London property, Madrid, London property. Oh yeah, we're going to scroll them down since they wanted to say that all of these folks were immune from federal charges. If the least that we could do is put their names on, then we'll put their names on. The New York residents. Sir Anthony and Lady C. Bomford. Sir Anthony. Alec Baldwin. Alec Baldwin. I'm not going to read all of these names, but if any stand out, we can talk about why they're significant today, or we can move forward. And I'm going to choose the latter. This is why we do not believe in celebrity worship. Lord and Lady Beaumont. Baron from Essex, England. Mike Bloomberg. Honorable Bruce and Penelope Bosom. Paris. I might be scrolling too slow, man. Let me turn my music back on. I'm gonna turn it up just a little bit louder now, so breathe. We're gonna get through this. Alistair Campbell. Naomi Campbell, London. This is why we do not believe in celebrity worship. Oh, they done opened up a whole fourth column. Oh my goodness. Now, while I thought I might be able to scroll down through these, I am realizing that this is 92 pages long. This is 92 pages long. Peter Cohen, Phil Collins. I'm not going to be able to get that right column. Not on this one. And I am not going to be able to go through as slowly as I thought I would have been able to. Fernando de Soto. Sounds like he descends from a colonizer. We'll let that song play one more time, and by the end of that time, we'll be done with this list. Peter Dubin, Duchess of York, Duke of York. Ed Epstein. Leonardo and Beatrice Ferragamo. Steve Forbes. Tom and Richard Forbes. Sandy Forbes. Chris Forbes. Rome, Italy. Lima, Peru. International sex trafficking. Either patrons, contacts, or co-conspirators. South Africa. Angeles, Lord and Lady Hanson, the Honorable Robert Hanson, Bob Hefner, Hermes, we got to the eyes. The link is above. If you find yourself interested in furthering that research, to make sure we document, this is the Maxine, this is the Ghislaine Maxwell Dox. So should we continue this research further, there are many, many more names. The significant point made there is that list was between 2004 and 2005. By 2007, Epstein was signing an agreement that barred his prosecution for numerous federal sex crimes. Point 12, that same agreement, the United States additionally agreed that it would not institute any federal criminal charges against any potential co-conspirators of Epstein. Potential. As co-conspirators of Epstein, Maxwell was consequently granted immunity. In the Southern District. Epstein ultimately pled guilty to procuring a minor for prostitution and is now a registered sex offender. So out of all of that international sex trafficking, he pled guilty to procuring a minor and registered. And that was the punishment. Filed September 21st, 2015. Case 1-15-CV-07433-LAP. The civil case between Virginia Joffre and Ghislaine Maxwell. 99 pages of potential, all of them off the hook for international sex trafficking charges going through Florida. Now, I know it's hard to read, so I will continue with the speed read element with the information off the screen. We ended off at 13. As a co-conspirator of Epstein, Maxwell was consequently granted immunity in the Southern District of Florida through the NPA. 14. Epstein ultimately pled guilty to procuring a minor for prostitution and is now a registered sex offender. 15. Rather than confer with the victims about the NPA, the United States Attorney's Office and Epstein agreed to a confidentiality provision in the agreement barring its disclosure to anyone. including Epstein's victims. As a consequence, the victims were not told about the NPA. On July 7th, 2008, a young woman identified as Jane Doe number one of Jeffrey Epstein's victims other than Giuffre, filed a petition to enforce her rights under the Crime Victims' Rights Act, CVRA, 18 U.S.C. 3771, paragraph 3771. Crime Victims' Rights Act, CVRA, 18 U.S.C., paragraph 3771, alleging that the government failed to provide her the rights promised in CVRA with regard to the plea arrangement with Epstein. The litigation remains ongoing. On or about May 4th, 2009, Virginia Giuffre, identified then as Jane Doe number 102, filed a complaint against Jeffrey Epstein in the United States District Court for the Southern District of Florida. The complaint included allegations made by Giuffre that pertained to Maxwell. In pertinent part, the Jane Doe number 102 complaint described in detail how Maxwell recruited Giuffre, who was then a minor girl, to become a victim of sex trafficking by introducing Giuffre and Jeffrey Epstein. With the assistance of Maxwell, Epstein was able to sexually abuse Giuffre for years until Giuffre eventually escaped. The Jane Doe number 102 complaint contained the first public allegations made on behalf of Giuffre regarding Maxwell. As a civil litigation against Epstein moved forward on behalf of Giuffre and many other similarly situated victims, Maxwell was served with a subpoena for deposition. Her testimony was sought concerning her personal knowledge and role in Epstein's abuse of Jeffrey and others. To avoid her deposition, Maxwell claimed that her mother fell deathly ill and that consequently she was leaving the United States for London with no plans of ever returning. In fact, however, within weeks of using that excuse to avoid testifying, Maxwell had returned to New York. In 2011, 2 FBI agents located Giuffre in Australia, where she had been hiding from Epstein and Maxwell for several years, and arranged to meet with her at the U.S. consulate in Sydney. Giuffre provided truthful and accurate information to the FBI about Epstein and Maxwell's sexual abuse. Ultimately, as a mother and one of Epstein's many victims, Giuffre believed that she should speak out about her sexual abuse experiences in hopes of helping others who had also suffered from sexual trafficking and abuse. On December 23, 2014, Giuffre incorporated an organization called Victims Refuse Silence, Incorporated, a Florida not-for-profit corporation. Giuffre intended Victims Refuse Silence to change and improve the fight against sexual abuse and human trafficking. The goal of her organization was and continues to be to help survivors surmount the shame, silence, and intimidation typically experienced by victims of sexual abuse. Giuffre has now dedicated her personal life to helping victims of sex trafficking. On December 30th, 2014, Giuffre moved to join the ongoing litigation previously filed by Jane Doe 1 in the Southern District of Florida, challenging Epstein's non-prosecution agreement by filing her own joinder motion. Giuffre's motion described Maxwell's role as one of the main women who Epstein used to procure underage girls for sexual activities and primary co-conspirator and participant in his sexual abuse and sex trafficking scheme. In January 2015, Maxwell undertook a concerted and malicious campaign to discredit Giuffre and to so damage her reputation that Giuffre's factual reporting of what had happened to her would not be credited. As part of Maxwell's campaign, she directed her agent, Ross Gow, to attack Giuffre's honesty and truthfulness and accused Giuffre of lying. On or about January 3rd, 2015, speaking through her authorized agent, Maxwell issued an additional false statement to the media and public designed to maliciously discredit Giuffre. The statement contained the following deliberate falsehoods. A, that Giuffre's sworn allegations against Ghislaine Maxwell are untrue. B, that the allegations have been shown to be untrue. C, that Giuffre's claims are obvious lies. Maxwell, January 3rd, 2015 statement incorporated by reference Ghislaine Maxwell's original response to the lies and defamatory claims remains the same. An earlier statement that had falsely described Giuffre's factual assertions as entirely false and entirely untrue. Maxwell made the same false and defamatory statements as set forth above in the Southern District of New York and elsewhere in a deliberate effort to maliciously discredit Giuffre and silence her efforts to expose sex crimes committed around the world by Maxwell, Epstein, and other powerful persons. Maxwell did so with the purpose and effect of having others repeat such false and defamatory statements and thereby further damaged Giuffre's reputation. Maxwell did so with the full and effect of having others repeat such false defamatory statements and thereby further damage Giuffre's reputation. I think this statement is important, so I want to make sure it's captured on screen as well. Maxwell did so with the purpose and effect of having others repeat such false defamatory statements and thereby further damaged Giuffre's reputation. Case 1-15-CV07433-LAP, Document 1, filed 9/21/2015, page 7 of 12. Giuffre versus Maxwell. Civil defamation case. This is a case against an international sex trafficker, an intermediary identified as Ghislaine Maxwell. The more familiar we are with the cases that are used as precedents to prosecute sex traffickers, the stronger our tools, the stronger our argument, the stronger our position will be as we set off to create more secure Black households or secure Black households, to protect Black bodies, to protect Black babies. It is important to learn the statutes and laws and commandments of the Bible for Israelites. It is important to learn the Quran for the followers of Islam. It's important for Christians to stand on their word. And as Black men who have every capability and will to leave our mark here in America in the legacy of civil rights or criminal justice reform, or in the legacy of Black fatherhood, if there was just one thing that we may put our stamp on, it is now, as it is always should have been, the protection of our babies. Should we fail to learn how they continuously cite the same cases, over and over, then we will not be passing forward the legacy of even the Black Panthers. This is the work. I am not a lawyer, but maybe there is someone in our network who knows somebody that knows somebody, 6 degrees of separation, that when we tell them we've been having bullying occur from people in the online space with platforms or with LLCs who leverage the e-commerce sites to propagate juvenile prostitution, to propagate the death of Black women via rape and molestation. We have been attacked by those platforms. Are there any case laws that we should also study up on? Because as of today, we are able to talk about it. We can keep the discussion going. We can open up panels that allow for those who have survived domestic violence and rape and their family, their loved ones. They've had to be that shoulder, or they've had to be those bloody knuckles. And the only thing that we could do is be that voice or be that shoulder, be those tears being shed. For some of us, it got worse. We could only be the person to help wash the cars as the car wash was needed to raise the funds to bury the woman or the child. And these threats that we continue to see levied, if we're able to protect ourselves in this space, it goes a step towards being able to protect our children. We're up against a beast. This, make no mistake about it, is a rape culture country. It is supported and defended from the highest of the highest levels of policy, of theology, and even in just our social fabric. But we can breathe. The air we breathe is our air. The more air that we breathe, the less air will be available for them as their air gets more and more scarce. And as we continue to constrict their airwaves, we make more room for the sincere, for the genuine, for the authentic Black men in media. Our vision: secure Black households. A very lofty vision, but a vision nonetheless. Secure Black households. And if there was one mission, it would be to protect our children against sexual exploitation, to protect our babies. Again, it is nearly impossible to see everything that's on the screen in this docs, so we shall continue with it off screen, and I will read it. We're on page 7 of 12, and we are at 33. Maxwell made her statements to discredit Giuffre in close consultation with Epstein. Maxwell made her statements knowing full well they were false. Maxwell made her statements maliciously as part of an effort to conceal sex trafficking crimes committed around the world by Maxwell, Epstein, and powerful persons. Maxwell intended her false and defamatory statements set out above to be broadcast around the world and to intimidate and silence Giuffre from making further efforts to expose sex crimes committed by Maxwell, Epstein, and other powerful persons. Again, that is another statement that is so important. I have to make sure that it's on screen. That is a key takeaway when it comes to, well, what can we do about it? What is the solution, as often asked to Black men, as should be asked to Black men? We know what problems and issues prevail, not just in our homes, not just in autonomous communities, not even just in the collective, but these issues prevail even online, to the point where we cannot protect our spaces from sexual harassment, of subscribers. We can't protect, on a broader sense, even outside of our own shared spaces. Our children occupy spaces together, and we can't protect them in the online spaces where they interact from sexual predators, nor sexual harassment, sexual intimidation, coercion, any of the things that Maxwell was accused of. We know the problems exist where they'll try to coerce, where they'll try to groom, where they'll try to transport. And there is not much that we can do until we get to that point of saying enough as Black men. Until we get to the point of determining now is our turn to breathe. So I breathe as a part of emotional regulation. And then I zoom in, because this is one of the more important messages that cannot be left off of the screen. Is it large enough? Maxwell intended her false and defamatory statements set out above to be broadcast around the world and to intimidate and silence Giuffre from making further efforts. To intimidate and silence Giuffre from making further efforts to expose sex crimes committed by Maxwell, Epstein, and other powerful persons. I had to make sure that hit the screen. There are key takeaways that we find in these slides. This is the Ghislaine Maxwell Dox. It is a part of the case study on the promotion of juvenile prostitution. It should be at section C. I missed section C. Oh, I know what I did. Excuse me. For the record. We are at, excuse me. That's not right. My apologies. It's not editing either. What did it say right now? There it is. We're at section 1C of the case study on the promotion of juvenile prostitution by B1 Brother Moses. Section 1C, Giuffre versus Maxwell civil defamation suit. (36) Maxwell intended her false statements to be specific statements of fact, including a statement that she had not recruited an underage Giuffre for Epstein's abuse. Maxwell's false statements were broadcast around the world and were reasonably understood by those who heard them to be specific, factual claims by Maxwell that she had not helped Epstein recruit or sexually abuse Giuffre, and that Giuffre was a liar. On or about January 4th, 2015, Maxwell continued her campaign to falsely and maliciously discredit Giuffre. When a reporter on a Manhattan street asked Maxwell about Giuffre's allegations against Maxwell, she responded by saying, "I am referring to the statement that we made." The New York Daily News published a video of this response by Maxwell indicating that she made her false statement on East 65th Street in Manhattan, New York, within the Southern District of New York. Count 1, defamation. Still with me? Count 1, defamation. The plaintiff, Giuffre, realleges paragraphs 1 through 37 as if the same were fully set forth herein. Maxwell made her false and defamatory statements deliberately and maliciously with the intent to intimidate, discredit, and defame Giuffre. In January 2015 and thereafter, Maxwell intentionally and maliciously released to the press her false statements about Giuffre in an attempt to destroy Giuffre's reputation and cause her to lose all credibility in her efforts to help victims of sex trafficking. Maxwell additionally released to the press her false statements with knowledge that her words would dilute, discredit, and neutralize Giuffre's public and private messages to sexual abuse victims, and ultimately prevent Giuffre from effectively providing assistance and advocacy on behalf of other victims of sex trafficking or to expose her abusers. Using her role as a powerful figure with powerful friends, Maxwell's statements were published internationally for the malicious purpose of further damaging a sexual abuse and sexual trafficking victim, to destroy Giuffre's reputation and credibility, to cause the world to disbelieve Giuffre, and to destroy Giuffre's efforts to use her experience to help others suffering as sex trafficking victims. Maxwell personally and through her authorized agent, Ross Gow, intentionally and maliciously made false and damaging statements of fact concerning Giuffre as detailed above in the Southern District of New York and elsewhere. The false statements made by Gow were all made by him as Maxwell's authorized agent and were made with direct and actual authority from Maxwell as the principal. The false statements that Maxwell made personally and through her authorized agent Gow not only called Giuffre's truthfulness and integrity into question, but also exposed Giuffre to public hatred, contempt, ridicule, and disgrace. Maxwell made her false statements knowing full well that they were completely false. Accordingly, she made her statements with actual and deliberate malice, the highest degree of awareness of falsity. Maxwell's false statements constitute libel, as she knew that they were going to be transmitted in writing, widely disseminated on the internet and in print. Maxwell intended her false statements to be published by newspaper and other media outlets internationally, and they were, in fact, published globally, including within the Southern District of New York. Maxwell's false statements constitute libel per se, inasmuch as they exposed Giuffre to public contempt, ridicule, aversion, and disgrace, and induced an evil opinion of her in the minds of right-thinking persons. Maxwell's false statements also constitute libel per se, inasmuch as they tended to injure Giuffre in her professional capacity as the president of a non-profit corporation designed to help victims of sex trafficking, and inasmuch as they destroyed her credibility and reputation among members of the community that seeks her help and that she seeks to serve. Maxwell's false statements directly stated and also implied that in speaking out against sex trafficking, Giuffre acted with fraud, dishonesty, and unfitness for the task. Maxwell's false statements directly and indirectly indicate that Giuffre lied about being recruited by Maxwell and sexually abused by Epstein and Maxwell. Maxwell's false statements were reasonably understood by many persons who read her statements as conveying that specific intention and meaning. Maxwell's false statements were reasonably understood by many persons who read those statements as making specific factual claims that Giuffre was lying about specific facts. Maxwell specifically directed her false statements at Giuffre's true public description of factual events, and many persons who read Maxwell's statements reasonably understood that those statements referred directly to Giuffre's account of her life as a young teenager with Maxwell and Epstein. Maxwell specifically directed her false statements at Giuffre's true public description of factual events, and many persons who read Maxwell's statements reasonably understood that those statements referred directly to Giuffre's account of her life as a young teenager with Maxwell and Epstein. I'll put a pin right here to observe and infer that based on the information presented, victim 1, who was said to be under the age of 14 upon meeting them, and was also referred to as by another as Jane Doe number 102. So in U.S. versus Maxwell, as well as Jane Doe, as referred to as Jane Doe number 102, both could potentially be survivor Virginia Giuffre. I'd be having such a hard time remembering her name. You would think I'd be good at this, but no, I'm not good at this. I struggle with white females and white males' names, surnames and forenames. And salute. It is to our benefit that these documents were unsealed, because for years the court kept these documents under wraps. we only knew what was put out by the media. And in this case, yes, the internet is a form of media, but it's been too long since we've heard actual details about the largest international sex trafficking case that we may ever see in our right now lifetime. I know in my lifetime, this is the biggest one that I have ever heard about. This is the biggest international sex trafficking case that I have ever heard about in my lifetime. Others may know others, but in my lifetime, this is it. And we have access to the docs, so it is our job to actually bring out the cases that they were going off. What are the cases that they used to either validate or discredit witnesses or testimony, information? It's page 9 of 12, which means we're almost through with section 1. I thank everyone so far who has been able to come in and out of this live streamed presentation. I also thank the founder and co-founder, or the co-founders of the B1 Network, Black First Media Group, for gracing the chat, as well as for members of their prestige entourage who has often frequented some of my live streams. None as important as this. I thank those for also coming and joining us in this very draining, very necessary, but emotionally deregulating work, understanding the legality and the way that they get around us, the way that they make it easier to kill a victim 2, 3, 4, 5, 10, 100, 1,000 times. They can kill that victim 1,000 times through media. They can kill it through the injustice system. They can kill it through the subtle reminders. They can kill it through releasing, other media like hip hop songs that speak directly towards the rape culture, movies. They can kill the victims of rape, molestation. They can re-trigger the traumas that kill 60-year-old, otherwise healthy Black women. They can re-trigger the traumas that kill otherwise healthy 75-year-old Black mothers, grandmothers, great-grandmothers, Gigi moms. And they can re-trigger the 1960s. They can re-trigger experiences from the 1970s and re-kill the victims. They can re-trigger the 80s and the 90s and re-kill the victims. When we get to the 2000s, we're talking about the children of millennials. Boomers, baby boomers, Gen Xers, millennials, and then the rest of these young folks. And they also have a generation below the young folks. I'm almost 40 and I could be a grandfather. And none of us have been safe. None of us have found protection none of us have been able to move towards the defense of our people. Not from external, not from internal threats. There's been many fights. We fought hard, we fought well. The integration of schools, where the federal government was able to send us a few troops, a few hundred or a few thousand, maybe even just a handful of troops that allowed us to move from separate but unequal schools into the schools funded by white females and white males in their communities. That civil rights era opened up access to white people in neighborhoods and white people's money inside of their deposits, and the other ethnic groups weren't as strong as the dominant white folks. And so civil rights, in all sense and purposes, was a movement into white business. With that comes the burden of the legacy of disrespect and inhumanity towards women and children. That resounding sermon, that theological basis that says women should be silent and girls are the property of their husbands to be married off. Our work is to ensure that children are not property. In that sense, they're not our chattel. We did not leave the plantation as chattel to turn our children into chattel. Our women, which seems to be a bit possessive, Black women are not chattel. Regardless of what the laws state, in no way can a child consent to rape. In no way can a child consent to rape. We have to break it down in sound bites. In no way can a child consent to rape. Likewise, in no way will an adult offender be the victim. In no way will an adult offender be the victim. For the protection of Black babies and the legacy that we as authentic, genuine men, Black men, if there is but one mission that we should and without any objection be on one accord on, it must be the protection of Black bodies. In no way can a child consent to be raped, regardless of what those laws say, the protector PFAL laws. In no way. That is not our will. That is not our way. That's not our theology. That is an unjust law that says anything otherwise. That because she is 16 and 364 days, it was consent. No way. There is in no way a consent. from a child to be raped. Likewise, there is in no way an adult offender who is the victim. We need both. We need protection for the actual victims, and the reform needs to be anti-offender. I'll finish this, conclude, and I've been at it for a couple hours now, so I'll get some rest, and we shall continue, or we shall reconvene for section 2 at the next date. Page 9 of 12. Maxwell made her false statements knowing full well that they were completely false. Accordingly, she made her statements with actual and deliberate malice, the highest degree of awareness of falsity. Maxwell's false statements constitute libel as she knew they were going to be transmitted in writing, widely disseminated in internet and in print. Maxwell intended her false statements to be published by newspaper and other media outlets internationally, and they were, in fact, published globally, including within the Southern District of New York. Maxwell's false statements constitute libel inasmuch as they exposed Giuffre to public contempt, ridicule, aversion, and disgrace, and induced evil opinion of her in the minds of right-thinking persons. Maxwell's false statements also constitute libel per se, inasmuch as they tended to injure Giuffre in her professional capacity as the president of a non-profit corporation designed to help victims of sex trafficking, and inasmuch as they destroyed her credibility and reputation among members of the community that seeks her help and that she seeks to serve. Maxwell's false statements directly stated and also implied that in speaking out against sex trafficking, Giuffre acted with fraud, dishonesty, and unfitness for the task. Maxwell's false statements directly and indirectly indicate that Giuffre lied about being recruited by Maxwell and sexually abused by Epstein and Maxwell. Maxwell's false statements were reasonably understood by many persons who read her statements as conveying that specific intention and meaning. Maxwell's false statements were reasonably understood by many persons who read those statements as making specific factual claims that Giuffre was lying about specific facts. Maxwell specifically directed her false statements at Giuffre's true public description of factual events that many persons who read Maxwell's statements reasonably understood that those statements referred directly to Giuffre's account of her living as a young teenager with Maxwell and Epstein. Maxwell intended her false statements to be widely published and disseminated on television, through newspapers, by word of mouth, and on the internet. As intended by Maxwell, her statements were published and disseminated around the world. Maxwell coordinated her false statements with other media efforts made by Epstein and other powerful persons acting as Epstein's representatives and surrogates. Maxwell made and coordinated her statements in the Southern District of New York and elsewhere with the specific intent to amplify the defamatory effect of those statements would have on Giuffre's reputation and credibility. Maxwell made her false statements both directly and through agents who, with her general and specific authorization, adopted, distributed, and published the false statements on Maxwell's behalf. In addition, Maxwell and her authorized agents made false statements in reckless disregard of their truth or falsity and with malicious intent. With reckless disregard of their truth or falsity and with malicious intent to destroy Giuffre's reputation and credibility. I think that's the one. Reckless disregard of their truth or falsity and with malicious intent to destroy Giuffre's reputation and credibility. So I think that would be the quote that makes it into my slideshow. right? To prevent her from further disseminating her life story and to cause persons hearing or reading Giuffre's descriptions of truthful facts to believe her entirely. Maxwell made her false statements wantonly and with the specific intent to maliciously damage Giuffre's good name and reputation in a way that would destroy her efforts to administer her nonprofit foundation. They keep going back and forth. Is it a nonprofit or a not-for-profit? Those are different. I'll keep going. Or share her life story and thereby help others who have suffered from sexual abuse. As a result of Maxwell's campaign to spread false, discrediting, and defamatory statements about Giuffre suffered substantial damages in an amount to be proven at trial. Maxwell's false statements have caused and continue to cause Giuffre economic damage, psychological pain and suffering, mental anguish and emotional distress, and other direct and consequential damages and losses. We breathe for emotional regulation. Maxwell's campaign to spread her false statements intentionally was unusual and particularly egregious conduct. Maxwell's campaign to spread her false statements internationally was unusual and particularly egregious conduct. Maxwell sexually abused Giuffre and helped Epstein to sexually abuse Giuffre, and then, in order to avoid having these crimes discovered, Maxwell wantonly and maliciously set out to falsely accuse, defame, and discredit Giuffre. In so doing, Maxwell's efforts constituted a public wrong by deterring, damaging, and setting back Giuffre's efforts to help victims of sex trafficking. Accordingly, this is a case in which exemplary and punitive damages are appropriate. Punitive and exemplary damages are necessary in a case to deter Maxwell and others from wantonly and maliciously using a campaign of lies. I like that one too. A campaign of lies to discredit Giuffre and other victims of sex trafficking. Prayer for relief. Wherefore, plaintiff Giuffre respectfully requests judgment against defendant Maxwell, awarding compensatory, consequential, exemplary, and punitive damages in an amount to be determined at trial, but in excess of the $75,000 jurisdictional requirement. Costs of suit, attorney's fees, and such other and further relief as the court may deem just and proper. Jury demand. Plaintiff hereby demands a trial by jury on all causes of action asserted within this pleading, dated September 21st, 2015. David Boyce, Schiller, and Flexner, LLP. Sigrid McCauley, Pro Hoc Vice, pending. Boyce, Schiller, and Flexner, LLP. Ellen Brockner, Boyce, Schiller, and Flexner, LLP. Page 12. In conclusion. I'm not a lawyer. Whether there was libel, whether there was consistencies or inconsistencies between the Maxwell Docket, USA versus Maxwell, and Giuffre versus Maxwell, that information has now been presented and established. This was section 1. What will Ghislaine Maxwell be convicted of? This is a case study on the promotion of juvenile prostitution. At this point, I will add my concluding thoughts.
How to convince Black women, how
To believe that Black women are disposable.
how that you need to desperately pursue marriage with him, how
They are all around our lives: landlords, bosses, judges, doctors, teachers, and Jesus.
I'm trying to think about how they were able to accomplish that. The only thing that I can come up with is blind black male worship.
I keep saying it over and over again that spiritual debt is real.
How? Global trade. How to convince black women? How?
To believe that black women are disposable.
How? That you need to desperately pursue marriage with him? How?
They are all around our lives: landlords, bosses, judges, doctors, teachers, and Jesus.
I'm trying to think about how they were able to accomplish that. The only thing that I can come up with is blind black male worship.
I keep saying it over and over again that spiritual debt is real.
How? Global trade.
One more again. These are my concluding thoughts. They are not my words, of course. These are the words of both the court and the witnesses, and these are the words of our sisters who are actively supporting and serving black women and black young women, and in proximity, black girls who have been sexually assaulted, sexually abused, raped. I present 3 of our sisters as my closing thoughts who are actively supporting. They're actively supporting women who have experienced similar to what the intermediary, Ghislaine Maxwell, forced upon minors on an international stage. And for the works that the 3 black sisters whose voices you hear, 1, Cynthia G, 2, Black Woman Sphere, 3, Nyla Says, or Nyla's Vibes, those 3 voices are working towards establishing the same goal that genuine, authentic black men are striving towards. They use media in their way to ensure that there is a masculine feminine energy behind this movement. The feminine energy is strong, yet the feminine energy is constantly under attack. The masculine energy is weak, yet that weak masculine energy is the most prevalent energy from black men available. The voices that are pro status quo have thousands and thousands and thousands of hit the links. Type in anything into the Google search where they have your profile, and it is more likely that you will find the thousands and thousands and thousands of negative depictions, negative imagery, negative storylines, negative narrations, negative hate-filled rhetoric, hate content about weak black men, even those who may be genuine and authentic. You will find that even amongst those who could be considered a unicorn black man, though we are all imperfect. None of us are unicorns. All of us fail. We are all failures. But if there was any inkling, of a black man, then it is one who understands the context of what was presented today, as well as the content. I say one more again. And let me say it once more. The vision: secure Black households. The mission is to protect our Black babies. Protect our babies. Protect our babies from sexual exploitation.